Hello, you're watching Addleshaw Goddard's Employment Channel. In this week's headlines, the EAT confirms that prevention really is better than cure in a case about constructive dismissal. Is it unlawful to ask employees to retire at 67? Well, not in Sweden, says the ECJ. In the wake of the UK's abolition of a default retirement age, we consider how helpful this is for UK employers. Finally, breaking news that the discrimination net could be set to grow even wider, with proposals afoot to extend legal protection to TA reservists. Let's start then with the case of Asamoy and Spirit Pub Company. This looked at whether an employer had managed to prevent a breach of the implied term of trust and confidence from occurring when senior managers overruled a junior manager to clear an employee from disciplinary proceedings. Mr. Asamoy had worked for Spirit over a period of 16 years in its West London pub kitchens. He'd had a few run-ins during this time, receiving warnings about his conduct and raising grievances against a manager, which hadn't been upheld. After asking for a transfer to a different pub, his manager became Mr. Cooper. It wasn't long before Mr. Asamoy's relationship with Mr. Cooper became equally tense, set off initially when new contracts were introduced after a reorganisation, which Mr. Asamoy refused to sign. Things really flared up though in the run-up to Christmas, when Mr. Cooper found the kitchen to be understaffed and turning away customers. He called an emergency meeting the next day, but no one turned up. Mr. Cooper accused the kitchen staff of being absent without leave and suspended them all, pending investigation. In actual fact, Mr. Asamoy had been away on authorised leave on these days, which he'd previously agreed with Mr. Cooper. When Mr. Asamoy attended his investigatory meeting, held with two senior managers, it wasn't long before they realised that a mistake had been made and that Mr. Asamoy's absence was legitimate. They confirmed to him that no action would be taken and references to the suspension would be removed from his record. However, Mr. Asamoy was not best pleased and raised a grievance against Mr. Cooper. After a couple of fraught return to work meetings where Mr. Asamoy demanded an apology from Mr. Cooper, which was refused, and a transfer to another pub was discussed, Mr. Asamoy eventually resigned and brought a claim for unfair dismissal based on the way that he'd been treated by Mr. Cooper and the proposed new contract. The tribunal dismissed his claim. Although they found Mr. Cooper had acted in a way likely to damage trust and confidence by calling a meeting during Mr. Asamoy's holiday, saying he was absent without leave when he wasn't, and then refusing to apologise to him, the senior managers had prevented this from amounting to a breach of trust and confidence by believing Mr. Asamoy's version of events, telling him that no further action would be taken, and then offering to transfer him to another pub. Mr. Asamoy appealed though, saying that the tribunal had wrongly treated Mr. Cooper's breaches of trust and confidence as being cured by these actions of the senior managers. He relied on the case of Buckland and Bournemouth University in 2010, where the Court of Appeal had confirmed that it wasn't possible to cure a repudiatory breach once it had occurred. The EAT, however, dismissed Mr. Asamoy's appeal. They agreed with the tribunal and held that the tribunal hadn't misapplied Buckland. The EAT confirmed that the tribunal had decided that Mr. Cooper had behaved badly and in a way likely to damage trust and confidence, but that this wasn't serious enough to justify Mr. Asamoy resigning because it wasn't likely to destroy or seriously damage the relationship. The senior managers had dealt with the situation fairly at the investigatory meeting, which prevented the situation from escalating into a state of affairs justifying resignation. Where does this leave us then? Well, preventing a breach of the implied term of trust and confidence is possible, whereas curing a breach isn't. So to simplify things, it seems that the old adage really is the best. Prevention really is better than cure. I asked Emma Whiting then, a partner in Addleshaw Goddard's employment group, whether she thought there were any learning points for employers in this decision.
Well, I think it's a reassuring decision for employers, and I think Spirit took exactly the right steps in overturning the disciplinary sanction very quickly, and that placed them in the best possible position to be able to defend this constructive dismissal complaint. In terms of specific lessons, though, I think there's probably two that have come out of this decision. The first is really just emphasising the importance of independent investigation. Spirit appointed two managers who looked into the matter and overturned the disciplinary sanction straight away, no questions asked, and therefore that was pretty important in this case. On a more general level, what I'd say is an important point to take away from this is that prevention is better than cure, and therefore the quicker that you take steps to remedy a situation, the better this position will be. Thinking specifically about breakdowns in relationships, don't allow those to fester, take immediate steps to try to resolve those, and then you are going to be able to defend constructive dismissal complaints much all the more as a result of that.
Thanks, Emma. In our next case, we look at whether or not a national law can require employees to retire at 67. Well, the ECJ has just approved Sweden's national retirement age of 67, even though it ignores whether employees have sufficient pension available. Mr. Hornfeldt was employed on a part-time basis by the Swedish Postal Service for 20 years. For a lot of that time, though, he worked only 1 day a week. In Sweden, pensions are calculated by looking at income over an employee's career. Mr. Hornfeldt was therefore concerned that his pension wasn't going to be enough, given that he'd been part-time for so long. To boost his pension, he wanted to work for a couple of years beyond the Swedish retirement age of 67, but instead found his employment terminated. He brought proceedings seeking an annulment of this termination on the basis that the 67-year rule was discriminatory on the grounds of age. The ECJ found that the 67 rule wasn't a mandatory scheme of automatic retirement, but just laid down conditions under which employers could derogate from the principle of age discrimination by giving notice to employees at 67. There was nothing to stop employers entering into further fixed-term contracts with employees if they wanted to. Employees retiring with low pensions were also able to receive further support benefits. Overall then, looking at the legal position, the ECJ said they were happy that the Swedish retirement law wasn't contrary to the Equal Treatment Directive because it was an appropriate and necessary means of achieving the legitimate aims identified of avoiding the humiliation of older workers, allowing the government to adapt to demographic change and making it easier for younger people to enter the labour market. The ECJ found that the age of 67 was an appropriate and necessary means of achieving those legitimate aims because compulsory retirement ages are widely used by member states, and those member states do have a broad discretion to pursue different aims in social and employment policy. This decision is consistent with other ECJ decisions by concluding that promoting the recruitment of younger workers and preserving the dignity of older workers are all potentially legitimate aims. Whilst this may be reassuring for UK employers, there's still the difficult hurdle of demonstrating a particular retirement age is a proportionate means of achieving such aims. In the recent Selden litigation, which we reported on the channel in July, which concerned a retirement age of 65, the UK Supreme Court sent the question of proportionality back to the Employment Tribunal for consideration. We're still awaiting the outcome of this decision with interest, as it will hopefully provide employers with clearer guidance on what's permissible in the field of retirement ages. Again, I thought I'd ask Emma Whiting, who has a particular interest in discrimination issues, whether she thought this decision meant anything significant for employers in the UK.
Well, it's a very interesting decision and perhaps a surprising decision in reaching this outcome. However, I do think that for UK employers, the decision is of limited relevance, and I say that for two reasons. The first is that there aren't that many UK employers that have retained a compulsory retirement age, and therefore it is of limited application so far as the specific facts of this case are concerned. The second point, which is of more general application to direct age discrimination complaints, is that the findings of the European Court on proportionality may not be followed in a UK court ruling, and that is just, I say that because it's quite clear on the test cases and the cases we've had already that the UK approach is probably going to be much more robust on issues of proportionality and justification more generally. So unfortunately, I think we're in the position where we are going to have to wait for the tribunal's ruling in the Selden case for more clear and definitive guidance on the issue of proportionality.
Thanks, Emma. And finally, it appears that the discrimination net could be set to grow even wider, with proposals afoot to extend legal rights similar to those offered to pregnant women to Territorial Army Reservists, or TA. The Minister for Defence, Philip Hammond, is due to publish proposals in the autumn to increase the number of TA reservists in the armed forces, in the wake of plans to reduce the regular army by 20,000 by 2015. Currently, the TA only has 14,000 men capable of frontline duty, but the MOD does plan to increase this to 30,000 over the next 5 years. However, there are growing concerns that firms may not willingly allow their staff to take months off work to serve for their country. There's also been anecdotal evidence of some companies refusing to hire TA reservists because of the potential disruption that they may cause. As a result, ministers are considering introducing legal safeguards to allow people to take time off and then return to their previous position, and also to bar companies from asking potential employees whether or not they're members of the TA or intend to be. In these tough economic times, though, when many businesses are already under huge pressure, such changes are likely to be controversial. So to repeat this week's headlines to finish off, the EAT has confirmed that prevention really is better than cure in a case about constructive dismissal. The ECJ says that Sweden can lawfully retain a national law requiring employees to retire at 67, and there are proposals afoot to extend legal protection to TA reservists. That's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.